Welcome to Ask the Lawyer, International Edition, the radio show that brings you the latest trends in immigrating to the United States. Hosted by attorney Brian Figeroux of the law firm Figeroux Associates. This program is designed to provide valuable insights for those who wish to live, work, study, or invest in the U.S. Whether you're an international student seeking educational opportunities, an entertainer looking to break into the U.S. market, or a business owner wanting to expand your operations and tap into the vast U.S. economy, this show is for you. If you're an investor exploring options in the U.S. or someone with family or friends already living here, you won't want to miss the important information shared on Ask the Lawyer, International Edition. Each week, we dive into critical topics that help you navigate the complexities of U.S. immigration and business law. Special guests include experts in business development, elected officials supportive of immigration, business owners, and nonprofit leaders who provide real-world advice and guidance for those wanting to build a future in the U.S. The law firm of Figeroux Associates was founded not only to serve our clients, but to contribute to the greater good. We understand the importance of helping individuals and businesses achieve their American dreams, and we are committed to providing the legal expertise and support needed to make that happen. So whether you're an entrepreneur looking to open a branch of your business in the U.S., an investor ready to explore opportunities, or someone hoping to migrate and build a new life in America, you should tune in and learn from this informative program. Ask the Lawyer. International Edition is your resource for understanding U.S. immigration trends, business opportunities, and legal strategies. Call now. For personalized legal advice, contact the experienced attorneys at Figeroux Associates today. Our team is here to help you navigate the path to success in the U.S. Thank you for listening to Ask the Lawyer, International Edition with attorney Brian Figeroux. Visit us online at askthelawyer.us or call today to schedule your consultation.
Good day. My name is Brian Figeroux of the law firm Figeroux Associates. This is Ask the Lawyer. You got questions, we got answers. The number to call, the number to keep, the number to share is 855-768-8845. Again, 855-768-8845.
Hello, my name is Mary Campbell, legal assistant at the law firm of Figeroux Associates, and your presenter with a special immigration report. Consequences for green card holders staying outside the U.S. for more than a year. Lawful permanent residents, LPRs, commonly known as green card holders, are granted the privilege to reside and work in the United States indefinitely. However, maintaining this status requires adherence to certain residency obligations. One critical aspect is the duration of time an LPR spends outside the U.S. Extended absences can lead to significant consequences, including the potential loss of permanent resident status. Abandonment of permanent resident status. An absence from the United States for more than 1 year can result in a presumption of abandonment of LPR status. U.S. Citizenship and Immigration Services, USCIS, states that while brief travel abroad usually does not affect permanent resident status, extended absences may lead to a determination that the individual did not intend to make the U.S. their permanent home. This is particularly pertinent for absences exceeding 1 year. Reentry challenges after extended absence. Green card holders who remain outside the U.S. for over a year without obtaining a reentry permit may face challenges upon attempting to reenter. The green card alone may not be sufficient for reentry, and individuals might be required to obtain a returning resident visa, SB1, from a U.S. embassy or consulate. To qualify for an SB1 visa, applicants must demonstrate that they departed the U.S. with the intention of returning and that their prolonged absence was due to circumstances beyond their control. Impact on naturalization eligibility. Extended absences can disrupt the continuous residence requirement for naturalization. USCIS guidelines indicate that an absence of more than 6 months, but less than 1 year, may break the continuity of residence, unless the individual can provide evidence to the contrary. An absence of 1 year or more during the statutory period automatically breaks the continuity of residence. delaying eligibility for naturalization. Tax implications. For tax purposes, green card holders are considered U.S. tax residents and are required to file U.S. tax returns on their worldwide income, regardless of their physical location. Prolonged absences do not exempt LPRs from this obligation. Failure to file U.S. tax returns can have legal and financial consequences. Strategies to maintain permanent resident status during extended absences. To mitigate the risk of abandoning permanent resident status during extended absences, LPRs can take the following steps. 1. Obtain a reentry permit. Before departing the U.S. for an extended period, apply for a reentry permit using Form I-131. This permit allows LPRs to remain outside the U.S. for up to 2 years without risking abandonment of their status. 2. Maintain U.S. ties. Keep significant ties to the U.S., such as maintaining a U.S. address, bank accounts, a valid driver's license, and filing U.S. tax returns as a resident. These actions demonstrate an intent to return and maintain U.S. residency. 3. Seek legal advice. Consult with an immigration attorney to understand the implications of extended travel and to ensure compliance with all legal requirements. Green cards without an expiration date. Some green cards issued between January 1977 and August 1989 do not have an expiration date. While these cards remain valid, USCIS has proposed requiring holders of such cards to replace them to enhance security and update cardholder information. Replacing an old green card can prevent potential issues during travel or employment verification. Conclusion: green card holders must be mindful of the duration of their absences from the United States to maintain their LPR status. Extended stays abroad, especially those exceeding 1 year, can lead to a presumption of abandonment and complicate reentry into the U.S. Additionally, maintaining up-to-date documentation, such as replacing old green cards without expiration dates, is advisable to avoid potential complications. Consulting with an immigration attorney can provide personalized guidance tailored to individual circumstances. Are you a religious worker looking to come to the U.S. to fulfill your mission? The law firm of Figeroux Associates, located in Brooklyn, New York, is here to help you navigate the complex R1 visa process. Whether you're a minister, missionary, or religious professional, our experienced immigration attorneys can assist with every step, from securing a U.S.-based sponsor to filing petitions with USCIS and preparing for your consular interview. Don't let the paperwork stand in the way of your spiritual calling. Schedule a consultation today at www.askthelawyer.us or call 855-768-8845 to discuss your case with our legal team. Figeroux Associates, your trusted partner in U.S. immigration law for religious workers. Call Figeroux Associates today.
Do you have a family member overseas that you want to bring to the United States? The law firm of Figeroux Associates, located in Brooklyn, New York, is here to help. Our experienced immigration attorneys specialize in family-based green card petitions, guiding you step by step through the process to reunite you with your loved ones. Whether you're a U.S. citizen or a green card holder, we will ensure your petition is handled smoothly and efficiently. Plus, we can help you understand how filing for a green card may impact your relative's visitor visa. Schedule a consultation today. Visit askthelawyer.us or call 855-768-8845 to discuss your case with our skilled legal team. Figeroux Associates, your trusted partner in family immigration law.
Hi, my name is Brian Anthony Figeroux, and you are listening to Ask the Lawyer with my father, Brian Figeroux.
Citizenship. Applications in 2025 amidst heightened scrutiny by the Trump administration. The process of applying for U.S. citizenship has always been complex, but in 2025, under the Trump administration's intensified immigration policies, the path to naturalization has become even more challenging. With an ongoing crackdown on immigrants, naturalization applications face increased scrutiny, particularly for those who obtained green cards through marriage. If the marriage ended in a contentious divorce, applicants may face additional hurdles, including potential interference from a vindictive ex-spouse. Given these obstacles, seeking experienced legal representation is more crucial than ever. This article analyzes the current climate surrounding citizenship applications, the risks posed by past relationships, and why working with a seasoned immigration attorney is critical to successfully navigating the process. The Trump administration's war on immigrants. Since returning to office in 2025, President Trump has reinforced his administration's hardline stance on immigration. A key focus of his second term has been limiting pathways to U.S. citizenship, particularly by increasing scrutiny on applications. Several measures have been implemented to slow down or deny applications, including stricter review of marriage-based green cards. The USCIS, United States Citizenship and Immigration Services, has intensified investigations into marriage-based green cards with a greater focus on potential fraud, even after divorce. Longer processing times. Citizenship applications now face prolonged review periods, with additional background checks and higher denial rates. More requests for evidence, RFEs. Applicants are now more likely to receive RFEs, requiring them to submit additional proof of their eligibility, adding further delays. Political and racial biases. Immigrants from specific countries and ethnic backgrounds face disproportionate scrutiny, a hallmark of previous Trump immigration policies that has resurfaced. For those who obtained a green card through marriage and are now applying for citizenship post-divorce, these policy changes present significant challenges. The complications of marriage-based green cards and divorce. One of the biggest hurdles for naturalization applicants who obtain their green card through marriage is proving that their marriage was legitimate, especially if the relationship ended poorly. USCIS has historically been skeptical of marriage-based green cards, but under the Trump administration's policies, there is an even stronger presumption of fraud. Potential issues when applying for citizenship. Post-divorce. 1. USCIS scrutiny over the validity of the marriage. Officers may dig into the marriage history, looking for inconsistencies that could suggest fraud. If the divorce was acrimonious, USCIS may see it as a red flag. 2. Ex-spouse interference. In contentious divorces, an ex-spouse could deliberately provide false or misleading information to USCIS. If the ex-spouse claims the marriage was fraudulent or submits derogatory statements, it could result in the applicant's naturalization denial. 3. Additional proof required. USCIS may require extensive evidence that the marriage was genuine, including affidavits, financial records, photographs, and testimonies. A request for evidence, RFE, or notice of intent to deny, NOID, could be issued, demanding more proof or an explanation for discrepancies. Legal challenges in citizenship. Applications under stricter policies. With citizenship applications facing more obstacles, it is crucial for applicants, especially those with marriage-based green cards and past divorces, to anticipate and address potential complications early in the process. Common issues that could lead to citizenship. Denial, misinformation in previous immigration filings. If there are inconsistencies in the marriage-based green card application, they may be used against the applicant during the citizenship process. Allegations of marriage fraud. Even if untrue, an accusation from an ex-spouse can trigger a full investigation. Criminal or civil allegations stemming from divorce. If an ex-spouse has filed any restraining orders or legal complaints, these can negatively impact the application. Failure to meet continuous residence and good moral character requirements. USCIS may question whether the applicant has met the residency requirements or has maintained good moral character, especially if the ex-spouse presents damaging claims. Given these risks, citizenship applications should be handled by attorneys who are well-versed in immigration law and prepared to counter government scrutiny. The role of experienced immigration attorneys in 2025 applying for citizenship under a hostile immigration climate requires legal expertise. A seasoned immigration attorney can anticipate USCIS scrutiny and prepare a strong application, ensuring that all paperwork is accurate, complete, and well-documented. Defend against accusations from a vindictive ex-spouse, counteracting false claims and gathering evidence to prove the legitimacy of the marriage. respond to requests for evidence, RFEs, or notices of intent to deny, no IDs, crafting thorough responses to government inquiries to prevent application denials, represent clients in immigration interviews, preparing applicants for questioning and advocating on their behalf during USCIS interviews, appeal denied applications. If the application is denied, an attorney can file an appeal or motion to reopen the case. For applicants facing complex circumstances, securing legal representation is no longer optional. It is a necessity. More challenging than ever. The road to U.S. citizenship has never been easy, but in 2025, under President Trump's intensified immigration policies, it is more challenging than ever. Those who obtain their green cards through marriage and later divorced must navigate heightened scrutiny, potential interference from ex-spouses, and a system designed to slow or deny applications. To increase the chances of a successful naturalization process, applicants must be proactive, well-prepared, and legally protected. Seeking the guidance of experienced immigration attorneys, such as those at Figeroux Associates, is the best step toward ensuring a smooth and successful citizenship application. If you are facing immigration challenges, do not risk delays or denials. Consult with a legal professional today.
Are you applying for U.S. citizenship but facing complications? Under the Trump administration's harsh immigration policies, the process is tougher than ever, especially if you obtained your green card through marriage and later divorced. The government is scrutinizing applications, and a bitter ex-spouse could make things worse. At Figeroux Associates, we specialize in immigration law and will fight for your citizenship. We'll protect your rights, respond to government inquiries, and defend against false allegations. Don't let delays or denials stop your future. Call Figeroux Associates today at 855-768-8845 for a consultation. Visit us at 26 Court Street, Suite 701, Brooklyn, New York, 11242. Your citizenship is too important to leave to chance. Let us fight for you. Figeroux Associates. Justice, integrity, results.
Do you have a family member overseas that you want to bring to the United States? The law firm of Figeroux Associates, located in Brooklyn, New York, is here to help. Our experienced immigration attorneys specialize in family-based green card petitions, guiding you step by step through the process to reunite you with your loved ones. Whether you're a U.S. citizen or a green card holder, we will ensure your petition is handled smoothly and efficiently. Plus, we can help you understand how filing for a green card may impact your relative's visitor visa. Schedule a consultation today. Visit askthelawyer.us or call 855-768-8845 to discuss your case with our skilled legal team. Figeroux Associates, your trusted partner in family immigration law.
Are you an artist, band, or musician looking to perform in the United States but need help navigating the complex visa process? The law firm of Figeroux Associates, located in Brooklyn, New York, is here to assist. Our experienced immigration attorneys specialize in entertainer visas, including P1, P2, and P3 visas. We'll guide you through every step, from securing a U.S. sponsor to filing the necessary petitions and preparing for your consular interview. With our legal expertise, we'll ensure that your visa application process is smooth and stress-free so you can focus on what you do best, performing. Schedule a consultation today at visiting www.askthelawyer.us or call 855-768-8845. Figeroux Associates, your trusted partner in U.S. immigration law for entertainers.
Are you a green card holder? Protect your future and your family today by becoming a U.S. citizen. With the return of the Trump administration in 2025, immigration enforcement has intensified, putting even green card holders at risk of deportation. The law firm of Figeroux Associates in Brooklyn is here to help. Through our deportation inoculation drive, we're empowering green card holders to take the next step toward U.S. citizenship, the ultimate safeguard against deportation. Becoming a U.S. citizen offers more than just security. It opens doors to voting rights, expanded travel privileges, federal jobs, and the ability to sponsor family members for green cards. Don't let fear or confusion hold you back. Our experienced attorneys are here to guide you through the process, from determining your eligibility to preparing for your citizenship interview. The time to act is now. Call the law firm of Figeroux Associates at 855-768-8845 or visit us at askthelawyer.us to schedule a consultation. Your future is worth it. Secure your rights and protect your family with citizenship today.
Hi, my name is Brian Anthony Figeroux, and you are listening to Ask the Lawyer with my father, Brian Figeroux.
Our weekly immigration news roundup is brought to you by the law firm of Figeroux Associates. For a consultation on any immigration or legal matter, please call 855-768-8845. That's 855-768-8845. For full stories and more immigration news, visit www.theimmigrantsjournal.com. That's www.theimmigrantsjournal.com.
Hello, my name is Mary Campbell, legal assistant at the law firm of Figeroux Associates, and your presenter with a special immigration report. Bronx immigration attorney sentenced to nearly 6 years in prison for $16 million fraud scheme. Bronx, NY. A Bronx-based immigration attorney was sentenced Wednesday, February 26, to 70 months in federal prison for his role in a large-scale immigration fraud scheme that defrauded his clients out of $16 million. Kofi Amankwa, 70, was also ordered to pay restitution in the full amount of $16 million, along with an additional $13 million in penalties. The announcement was made by Matthew Podolsky, acting United States Attorney for the Southern District of New York. Amankwa, who operated a law office in the Bronx, was found guilty of taking advantage of vulnerable immigrants, many of whom were seeking a better life in the United States. His actions not only caused significant financial harm to his clients, but also led to devastating consequences for their immigration status. People who immigrate to America are often vulnerable and simply trying to build better lives for themselves and their loved ones. New York Attorney General Letitia James stated in a press release following Amankwa's sentencing, "When these immigrants sought help from attorneys claiming to act in their best interests, they were taken advantage of and harmed instead." According to federal investigators, Amankwa's fraudulent scheme exploited the Violence Against Women Act, VAWA, which allows undocumented immigrants who are victims of abuse to apply for legal status. He falsely claimed that his clients were being abused by U.S. citizen children in order to make them eligible for the benefits provided under VAWA. However, Amankwa never verified these allegations and, in many cases, did not even bother to ask his clients about their personal situations. Amankwa's actions extended beyond fraudulent paperwork. He advised his clients to leave the United States and re-enter the country to obtain a passport stamp that would put them on a path to legal residency. Unfortunately, the scheme often backfired, resulting in the deportation of many immigrants who trusted Amankwa's guidance. The U.S. Department of Justice, alongside the New York Attorney General's office, initiated investigations into Amankwa's activities, uncovering a pattern of exploitation spanning several years. His firm charged clients thousands of dollars per case, knowing full well that many would not obtain the legal status they sought. As part of the sentencing, U.S. District Judge Catherine Polk-Fala emphasized the gravity of Amankwa's actions, noting that his fraudulent activities not only caused financial harm, but also severely impacted the lives and futures of those he swindled. In addition to the financial restitution, Amankwa faces the prospect of a lengthy prison sentence, underscoring the serious consequences of defrauding vulnerable populations, particularly those navigating the complex and often uncertain process of U.S. immigration. This case serves as a stark reminder of the risks immigrants face when seeking legal assistance, especially when they turn to dishonest individuals who prey on their vulnerabilities. The Justice Department and New York Attorney General's office have pledged to continue efforts to protect immigrants and hold accountable those who take advantage of them. Immigrants from the Caribbean were among those defrauded.
Arle Lou Izon is a criminal, now deceased and indicted by the federal government for defrauding thousands of Grenadians. If you or a family member is a victim of Arle Lou Izon and are in deportation proceedings or any immigration matters pending in immigration court, please call the law firm of Figeroux Associates at 855-768-8845. That's 855-768-8845.
If your spouse has overstayed their visa and you want to help them obtain a green card, we can help. The process of adjusting status can be complex, especially if there was an overstay. But the law firm of Figeroux Associates, located in Brooklyn, New York, has the experience and expertise to guide you through it. Our team of immigration lawyers will assist you every step of the way, from filing petitions to representing you at interviews. Schedule a consultation today at www.askthelawyer.us or call us at 855-768-8845. Get the right legal help when it matters most.
Are you a religious worker looking to come to the U.S. to fulfill your mission? The law firm of Figeroux Associates, located in Brooklyn, New York, is here to help you navigate the complex R1 visa process. Whether you're a minister, missionary, or religious professional, our experienced immigration attorneys can assist with every step, from securing a U.S.-based sponsor to filing petitions with USCIS and preparing for your consular interview. Don't let the paperwork stand in the way of your spiritual calling. Schedule a consultation today at www.askthelawyer.us or call 855-768-8845 to discuss your case with our legal team. Figeroux Associates, your trusted partner in U.S. immigration law for religious workers. Call Figeroux Associates today.
Hi, my name is Brian Anthony Figeroux, and you are listening to Ask the Lawyer with my father, Brian Figeroux.
International trade and global businesses, legal and business support for entrepreneurs and startups, navigating legal challenges as a small business owner. Starting and running a small business requires vision, strategy, and legal foresight. Entrepreneurs often face a labyrinth of regulatory requirements, contracts, and compliance hurdles, which, if mismanaged, can lead to costly disputes or financial setbacks. This is where Figeroux Associates' Small Business Solutions Division steps in. Located at 26 Court Street, Suite 701, downtown Brooklyn in New York, this legal service arm specializes in business formation, contract drafting, compliance, intellectual property protection, and dispute resolution for small enterprises. For business owners, securing the right legal guidance is not just a safety net, it's a competitive advantage. Legal business challenges facing entrepreneurs and startups. Running a business involves legal risks at every stage. From registering a business to drafting contracts and resolving disputes, entrepreneurs must ensure they are legally protected. Common challenges include business formation. Choosing between an LLC, corporation, or sole proprietorship affects taxation, liability, and operational flexibility. Contracts and agreements. Poorly drafted contracts can lead to financial losses and legal disputes. Employment and labor laws. Hiring employees requires compliance with state and federal labor regulations. Tax compliance. Navigating local, state, and federal tax obligations is critical to avoiding penalties. Intellectual property, IP, protection. Protecting trademarks, patents, copyrights, and trade secrets prevents competitors from misusing proprietary business assets. Figeroux Associates provides tailored legal solutions to help entrepreneurs navigate these challenges while ensuring business growth and sustainability. Core services of the Small Business Solutions Practice. 1. Business formation and structuring. Selecting the right legal structure impacts a company's liability, taxation, and regulatory compliance. Figeroux Associates guides entrepreneurs through choosing between sole proprietorship, simple but offers no liability protection; limited liability company, LLC, combines liability protection with tax flexibility; corporation, C Corp or S Corp, best for businesses seeking investors or scalability; partnerships, ideal for businesses with multiple owners but requires solid agreements. The firm assists with business registration, filing articles of incorporation, and obtaining necessary permits to ensure a smooth and legally sound business launch. 2. Contract drafting, review, and negotiation. Contracts are the backbone of business transactions. A poorly written contract can result in financial loss, litigation, or damaged business relationships. Figeroux Associates specializes in drafting and reviewing. Partnership agreements, vendor and supplier contracts, employment agreements, lease agreements for commercial spaces, non-disclosure and confidentiality agreements. The firm ensures contracts are legally sound, enforceable, and tailored to the client's specific business needs. 3. Employment law compliance. Employers must comply with state and federal employment laws covering hiring and termination policies, wage and hour compliance, Fair Labor Standards Act, FLSA, anti-discrimination and harassment policies, employee benefits, and workers' compensation. Figeroux Associates helps small businesses develop employment contracts, workplace policies, and compliance measures to protect against lawsuits and regulatory penalties. 4. Business dispute resolution and litigation. Disputes are inevitable in business. Whether it's a breach of contract, partnership disagreement, or customer complaint, having legal representation can prevent costly consequences. The firm's dispute resolution services include mediation and arbitration, litigation defense, debt recovery and collections, breach of contract resolution. Figeroux Associates prioritizes out-of-court settlements to minimize costs and disruptions while ensuring clients' rights are protected. 5. Intellectual property protection. For businesses with unique products, logos, or proprietary technologies, intellectual property, IP, protection is critical. Figeroux Associates assists with trademark registration and defense, copyright protections, for creative works, patent applications, trade secret protections. IP protection ensures brand exclusivity, prevents unauthorized use, and enhances business valuation. 6. Tax and regulatory compliance. Understanding tax obligations is crucial for business longevity. The firm provides legal guidance on business tax filings and deductions, sales tax compliance, tax disputes and IRS audits, franchise tax regulations. Navigating state and federal tax laws ensures compliance while maximizing financial benefits. Why choose Figeroux Associates? Experienced business attorneys, legal experts who understand the complexities of small business law. Comprehensive business solutions, from startup formation to tax compliance and litigation defense. Strategic risk management, proactive legal guidance to prevent disputes and financial losses. Dedicated client support, tailored services that prioritize long-term business success. Schedule a consultation. Whether you're launching a startup, expanding a business, or dealing with legal challenges, Figeroux Associates can help. Address: 26 Court Street, Suite 701, downtown Brooklyn, New York. Consultation: visit askthelawyer.us to take control of your business future. Schedule a legal consultation today.
Are you an artist, band, or musician looking to perform in the United States but need help navigating the complex visa process? The law firm of Figeroux Associates, located in Brooklyn, New York, is here to assist. Our experienced immigration attorneys specialize in entertainer visas, including P1, P2, and P3 visas. We'll guide you through every step, from securing a U.S. sponsor to filing the necessary petitions and preparing for your consular interview. With our legal expertise, we'll ensure that your visa application process is smooth and stress-free so you can focus on what you do best, performing. Schedule a consultation today at visiting www.askthelawyer.us or call 855-768-8845. Figeroux Associates, your trusted partner in U.S. immigration law for entertainers.
Are you applying for U.S. citizenship but facing complications? Under the Trump administration's harsh immigration policies, the process is tougher than ever, especially if you obtained your green card through marriage and later divorced. The government is scrutinizing applications, and a bitter ex-spouse could make things worse. At Figeroux Associates, we specialize in immigration law and will fight for your citizenship. We'll protect your rights, respond to government inquiries, and defend against false allegations. Don't let delays or denials stop your future. Call Figeroux Associates today at 855-768-8845 for a consultation. Visit us at 26 Court Street, Suite 701, Brooklyn, New York, 11242. Your citizenship is too important to leave to chance. Let us fight for you. Figeroux Associates, justice, integrity, results.
Are you a green card holder? Protect your future and your family today by becoming a U.S. citizen. With the return of the Trump administration in 2025, immigration enforcement has intensified, putting even green card holders at risk of deportation. The law firm of Figeroux Associates in Brooklyn is here to help. Through our deportation inoculation drive, we're empowering green card holders to take the next step toward U.S. citizenship, the ultimate safeguard against deportation. Becoming a U.S. citizen offers more than just security. It opens doors to voting rights, expanded travel privileges, federal jobs, and the ability to sponsor family members for green cards. Don't let fear or confusion hold you back. Our experienced attorneys are here to guide you through the process, from determining your eligibility to preparing for your citizenship interview. The time to act is now. Call the law firm of Figeroux Associates at 855-768-8845 or visit us at askthelawyer.us to schedule a consultation. Your future is worth it. Secure your rights and protect your family with citizenship today.
If your spouse has overstayed their visa and you want to help them obtain a green card, we can help. The process of adjusting status can be complex, especially if there was an overstay. But the law firm of Figeroux Associates, located in Brooklyn, New York, has the experience and expertise to guide you through it. Our team of immigration lawyers will assist you every step of the way, from filing petitions to representing you at interviews. Schedule a consultation today at www.askthelawyer.us or call us at 855-768-8845. Get the right legal help when it matters most.
Hi, my name is Brian Anthony Figeroux, and you are listening to Ask the Lawyer with my father, Brian Figeroux.
How a religious worker living overseas can successfully apply for an R visa to perform religious work in the U.S. For religious workers living overseas, the R1 visa provides an opportunity to come to the United States and serve their religious community. Whether you are a minister, a missionary, or a religious professional, this visa allows you to perform religious work on behalf of a legitimate U.S.-based religious organization. The R1 visa is an essential tool for churches, temples, mosques, and other religious institutions in the U.S. that rely on foreign workers to fulfill spiritual needs and carry out religious missions. In this comprehensive analysis, we will explore the process of applying for an R1 visa, covering the eligibility requirements, step-by-step application process, consular involvement, and practical advice for overseas religious workers seeking to come to the United States to perform religious work. We'll also address potential challenges and provide helpful tips for navigating U.S. immigration law in this context. Understanding the R visa category. The R1 visa is a non-immigrant visa for individuals who wish to come to the U.S. temporarily to perform religious work. This visa is available to individuals who are part of a bona fide nonprofit religious organization in the United States, and it applies to various religious roles, such as ministers, missionaries, and those working in religious vocations or occupations. Key features of the R1 visa: temporary religious work. The R1 visa is specifically for individuals entering the U.S. to work in a religious capacity for a recognized religious organization. This includes ministers, religious instructors, or those involved in other religious vocations. Duration. The R1 visa is typically issued for an initial period of up to 30 months, 2.5 years, and can be extended for an additional 30 months, with a total maximum stay of 5 years. Family. R1 visa holders can bring their spouse and unmarried children under 21 years of age to the U.S. under R2 visas. However, R2 visa holders cannot work in the U.S. but can attend school. Path to permanent residency. While the R1 visa is a non-immigrant visa, it does allow for dual intent, meaning religious workers can apply for permanent residency, green card, later if they meet the eligibility requirements. To qualify for an R1 visa, the applicant and their religious organization must meet several criteria, and the application process involves both U.S. Citizenship and Immigration Services, USCIS, and the U.S. consulate in the applicant's home country. 2. Eligibility requirements for an R1 visa. Before applying for an R1 visa, it's essential to ensure that both the religious worker and the U.S.-based religious organization meet the required criteria. These include: 1. Religious worker qualifications. To qualify for an R1 visa, the applicant must demonstrate that they are part of a recognized religious organization and that they will perform religious work in the U.S. specifically. Membership in the religious organization. The applicant must have been a member of the religious denomination for at least 2 years prior to applying for the R1 visa. Full-time employment. The religious work must be full-time, defined as at least 35 hours per week. This work must involve a traditional religious function, such as teaching religion, conducting worship services, or performing missionary work. Types of religious work. The applicant must be a minister, religious professional, or someone working in a religious vocation, such as a monk or nun, or occupation, such as a translator of religious texts. 2. U.S.-based religious organization requirements. The religious organization that will employ the worker in the U.S. must meet the following criteria. Nonprofit status. The organization must be a nonprofit religious organization recognized by the U.S. Internal Revenue Service, IRS, as tax-exempt under Section 503 of the IRS Code. Ability to pay. The organization must demonstrate its ability to provide financial compensation or support to the religious worker during their stay in the U.S. Valid religious purpose. The organization must engage in traditional religious functions, such as conducting worship services, religious education, or missionary work. Once both the applicant and the religious organization meet these eligibility requirements, the application process can begin. 3. Step-by-step process for applying for an R visa. Step 1. U.S.-based religious organization files Form I-129. The application process for an R1 visa starts with the U.S.-based religious organization filing Form I-129, Petition for an Immigrant Worker. This petition is filed with U.S. Citizenship and Immigration Services, USCIS, and is necessary to prove that the religious worker meets all the requirements for the R1 visa. Supporting documentation. Along with Form I-129, the organization must submit evidence of its nonprofit status, proof of the religious worker's qualifications, religious training, membership, and a detailed description of the duties the worker will perform in the U.S. Filing fee. As of 2024, the filing fee for Form I-129 is $460. It's crucial to check the USCIS website for the most up-to-date fees before submitting the petition. Processing time. USCIS processing times for Form I-129 can vary, but they generally take several months. However, premium processing is available for an additional fee, which guarantees a decision within 15 calendar days. Step 2. Wait for USCIS approval. Once USCIS receives Form I-129, they will review the petition and supporting documentation. If everything is in order, they will approve the petition and issue a Notice of Approval, Form I-797. This approval is necessary before the religious worker can apply for an R1 visa at the U.S. consulate in their home country. Premium processing. If time is a critical factor, the religious organization can opt for premium processing to expedite the approval of the I-129 petition. Step 3. Apply for the R visa at the U.S. consulate. After the I-129 petition is approved by USCIS, the religious worker must apply for the R1 visa at the U.S. consulate or embassy in their home country. This stage involves completing an online application and attending an interview at the consulate. Complete Form DS-160. The religious worker must fill out Form DS-160, the online non-immigrant visa application. This form collects personal information about the applicant, including details about their background, employment history, and the purpose of their visit to the U.S. Pay visa fees. The visa application fee for an R1 visa is currently $190 as of 2024. Applicants should check the latest visa fee rates on the U.S. Department of State website. Schedule a visa interview. After submitting the DS-160 form, the applicant must schedule an interview at the nearest U.S. consulate or embassy. The interview wait times vary depending on the location, so it's advisable to schedule as early as possible. Step 4. Attend the visa interview. The visa interview is a critical step in the process. During the interview, the consular officer will review the applicant's petition, supporting documents, and ask questions to confirm the purpose of the trip and the applicant's qualifications. Documents to bring. The applicant should bring the following to the visa interview: A valid passport with at least 6 months of validity remaining. A visa fee payment receipt. DS-160 confirmation page. A Form I-797. Notice of approval from USCIS. Supporting documentation from the religious organization, such as evidence of the applicant's qualifications and the purpose of the trip. Interview questions. The consular officer will likely ask about the nature of the religious work, the applicant's membership in the religious organization, and their intended stay in the U.S. The officer may also ask about ties to the applicant's home country to ensure that they will return after completing their religious work. Step 5. Visa approval and entry into the U.S. If the visa is approved, the applicant will receive their passport with an R1 visa stamp. This visa allows them to travel to the U.S. and begin their religious work. Port of entry. Upon arriving in the U.S., the religious worker will be inspected by U.S. Customs and Border Protection, CBP, officers at the port of entry. CBP officers will review the visa and issue an I-94 arrival/departure record, which will indicate the length of time the worker is authorized to stay in the U.S. Commencement of religious work. Once admitted to the U.S., the religious worker can begin their duties as outlined in the approved I-129 petition. 4. Key considerations for our visa applicants. 1. Extension of stay and maximum duration. The initial R1 visa is typically issued for a period of up to 30 months. Religious workers who wish to continue their work in the U.S. can apply for an extension of their stay, with a maximum total stay of 5 years. To apply for an extension, the religious organization must file another Form I-129 on the worker's behalf. 2. Path to permanent residency. While the R1 visa is a temporary, non-immigrant visa, it allows for dual intent, meaning the religious worker may eventually apply for a green card, permanent residency, if they meet the eligibility criteria. This can be done through the EB-4 Special Immigrant category, which is specifically for religious workers who have been employed in the U.S. for a certain period of time. 3. Family members. Spouses and unmarried children under 21 of R1 visa holders can apply for R2 visas to accompany or join the religious worker in the U.S. While R2 visa holders are not allowed to work in the U.S., they are permitted to attend school or pursue other educational opportunities. 5. that R1 visa offers a vital pathway for religious workers from overseas to come to the United States and contribute to the religious and spiritual life of communities across the country. From ministers and missionaries to religious professionals working in a vocation or occupation, the R1 visa allows religious workers to fulfill their callings while performing critical roles within their organizations. The process involves several steps, from securing sponsorship from a U.S.-based religious organization to filing petitions with USCIS and attending a consular interview. While the process can seem complex, careful preparation and following the specific requirements will help ensure a successful visa application. For religious workers seeking long-term residency, the R1 visa also opens the door to potential green card eligibility under the EB4 category. Whether for a short-term mission or a longer-term commitment, the R1 visa is a valuable option for those who wish to serve in the U.S. religious. The law firm of Figeroux Associates, which has over 25 years practicing immigration law, can help you navigate the process and avoid common pitfalls. To schedule an appointment, visit www.askthelawyer.us or call 855-768-8845. The lawyer you hire does make a difference.
Attention entrepreneurs and international businesses. Are you looking to expand your business into the US or protect your small business legally? Look no further than Figeroux Associates in Brooklyn, New York. Our International Trade and Global Business Division helps foreign companies navigate U.S. regulations, register businesses, and recover outstanding debts. Meanwhile, our Small Business Solutions Division offers expert legal advice on business formation, contracts, employment law, and tax compliance, helping you avoid costly mistakes. Don't take legal risks with your business. Protect your future with Figeroux Associates. Schedule your consultation today at www.askthelawyer.us or call us at 855-768-8845. We are located at 26 Court Street, Suite 701, downtown Brooklyn, New York. Small Business Solutions, helping business expand.
Do you have a family member overseas that you want to bring to the United States? The law firm of Figeroux Associates, located in Brooklyn, New York, is here to help. Our experienced immigration attorneys specialize in family-based green card petitions, guiding you step by step through the process to reunite you with your loved ones. Whether you're a U.S. citizen or a green card holder, we will ensure your petition is handled smoothly and efficiently. Plus, we can help you understand how filing for a green card may impact your relative's visitor visa. Schedule a consultation today. Visit askthelawyer.us or call 855-768-8845 to discuss your case with our skilled legal team. Figeroux Associates, your trusted partner in family immigration law.
Do you have a legal issue, question, or concern? Turn to Ask the Lawyer. You have questions? We've got answers. For a consultation or to refer a client, visit www.askthelawyer.us. Again, www.askthelawyer.us. You can also register for our paralegal program, get legal news, business consults, or other information on educational issues. Yes, Ask the Lawyer. You have questions? We've got answers. For a consultation or to refer a client, visit www.askthelawyer.us. Again, www.askthelawyer.us.
This show is a production of IQ Inc. Marketing. If you would like to advertise your product or service on this show to the U.S. and Caribbean markets and through our multicultural publications in New York, please call 866-435-3286 or send an email to info@myiqinc.com.
Thank you for listening to Ask the Lawyer International Edition with attorney Brian Figeroux of the law firm Figeroux Associates in New York. We hope you enjoyed the show, which featured immigration visitors visa, starting and doing business in New York, entertainment and business visas, religious visas, and much more. Whether you are outside the U.S. or have family in New York, the number to call, share, and keep is 855-768-8845. That's 855-768-8845. Please schedule a consultation with us at www.askthelawyer.us. That's www.askthelawyer.us. This is Ask the Lawyer, International Edition. You have questions? We've got the answers.